Now the judges will introduce themselves.
Mike, you're muted.
Sorry about that. Let's be certain that we're in New Jersey with a wild card team before we start introductions. Is that correct? Can New Jersey hear me?
This is the Ohio team. So, and it's the correct. This is the Ohio team. So yes, Ohio.
Okay, so our list is not accurate. I'll just ignore that and we'll ask. That's why I asked. Hello,
Okay.
my name is Dr. Michael Anderson. I am a retired professor and college administrator living in northern Minnesota. This is my 16th national contest. Congratulations for being here. Ed?
My name is Ed Philpott. I'm a trial lawyer. I practice law in New Hampshire, and I have a regional practice in trial law. I am also the former immediate past president of the New Hampshire Bar Association.
Molly.
My name is Molly Russell. I'm an attorney with Legal Aid of West Virginia. I specialize in domestic violence cases, and this is actually my first time judging, so I'm probably as nervous as you are. Will be great.
And the students. We can't hear you. Students, introduce yourselves, please.
My name is Tyler Horstman.
My name is Sydney Einen.
My name is Reed Andrews.
And your teacher?
Our teacher is Mr. Goodman.
Can you find a way in your home settings there to turn your volume up, please?
1 second.
Yeah, we can figure that out.
Sorry for the interruption, but we can barely hear you.
I gotcha. You're good.
Can you speak again? Test it.
You can go in and then.
Can you test your volume, please?
Hello, is the volume fixed?
Oh yeah, it says Netflix speakers. Yeah, it's not even using that one. That's why. All right, can you say something?
Can you hear us now?
Who spoke? Raise your hand. Yes, I heard that. Stay as close to your microphones as possible. For the sake of time, we're going to go ahead and get going on Unit 4, Question 1. So is that what you think we're doing too? Because we were in the wrong state. Unit 4, Question 1. All right, here we go. Unit 4, how have the values and principles embodied in the Constitution shaped American institutions and practices? Question 1. It would be inconsistent with the constitutional separation of the executive and legislative powers to let the prerogative, meaning the pardon power, be exercised by the latter. What were the framers' reasons for giving the president the pardon power? And do you agree or disagree with them? Bullet 1, according to the framer James Wilson, if the president abuses the pardon power, he can be impeached and prosecuted. Do you agree with Wilson? Why or why not? Second bullet, in your opinion, what constitutes high crimes and misdemeanors? You may begin.
Mr. Chairman, while I agree that the power to pardon was best served being given to the executive branch, history has shown that some of the reasoning was flawed and that the scrutiny of the nation has not provided a significant check on its use. At the Virginia Ratifying Convention, framer George Mason suggested that presidential pardon should require senatorial approval similar to judicial nominations, thus providing a check on the pardon power. Others, such as Alexander Hamilton and James Madison, argued that the Senate was already too powerful and feared a strong legislative branch, and that giving the pardon power was much better suited for one man. As Hamilton stated in Federalist 74, that one man appears to be a more eligible dispenser of the mercy of government than a body of men regarding the pardon power, and Madison stated that larger numbers might exercise this power improperly. Framer James Wilson also contended the public would check who the president would pardon in regards to the public view of the office. However, history has shown that presidents have frequently used pardons in amnesty, as seen with over 20,000 pardons and commutations issued in the 20th century alone.
Mr. Chairman, I agree with Framer James Wilson's full quote that if a president be himself a party to the guilt, he can be impeached and prosecuted, thus indicating that while the pardon can provide an important check under Article 2, Section 4, it would not enable a president to use the pardon to protect themselves. As Alexander Hamilton noted in Federalist 74, the power to pardon can provide the president with an effective check in that a well-timed pardon to rebels or insurgents could be used to restore the tranquility of the Commonwealth, as George Washington confirmed in the Whiskey Rebellion in 1794. Hamilton also echoed Wilson's original quote, stating that a president can grant reprieves and pardons for offenses against the United States, except in cases of impeachment, meaning that they cannot pardon someone facing impeachment, nor themselves if they are to be impeached. As was noted in January, a pardon of those involved in the Capitol insurrection would not enable President Trump to avoid impeachment, and led to speculation that insurrectionists such as Jacob Chansley, the QAnon shaman, could even be called to testify against President Trump. He also asserted the idea of a self-pardon, and although plausible, the trial of King Charles, for example, proves the opposite.
Mr. Chairman, while briefly mentioned in Article 2, Section 4, both the Constitution and Congress failed to specify what constitutes as a high crime or misdemeanor, which has enabled the two houses of Congress to disagree over its meaning. I believe that a high crime or misdemeanor is any action that is uncharacteristic of the office in question and is in direct conflict with the benefit of the American people. The lack of a clear indication or historical precedence for what constitutes a high crime or misdemeanor has left the two houses of Congress attempting to decipher the framers' intent from historical passages, such as Federalist 65, where Alexander Hamilton contended that such actions are of a nature which may with peculiar propriety be denominated political and create injuries to the society itself. Simply put, this could mean that an impeachable offense is anything not typically associated with the office. This position was further addressed when Gerald Ford, in suggesting the possible impeachment of Justice William O. Douglas, stated that an impeachable offense is whatever a majority of the House of Representatives considers it to be at that moment in history. In effect, this obscure meaning of this phrase has rendered the impeachment process meaningless, which has enabled actions such as President Trump's incitement of rebellion on January 6th to be considered impeachable by the House of Representatives, but not worthy of conviction by 43 Republicans in the Senate. We are now ready for follow-ups.
I have a question about your team's discussion of high crimes and misdemeanors. I'm glad you did that. But I want to combine some of the things you said and ask you this question. Does a poor use or bad use of the pardon constitute a high crimes and misdemeanor?
Mr. Chairman, I would argue that in the case of, say, an arbitrary use of power, the argument could be made that that could constitute as high crimes and misdemeanors.
It sure could, but you need to tell me what arbitrary is.
An arbitrary use of power would be, for example, when President Trump was pardoning, his lame duck period, was pardoning many people that were his business associates or close personal friends, or even when he tried to use the preemptive pardons for people who hadn't even committed a crime yet. An arbitrary use of power is simply when the pardon power isn't used as it is mentioned in the Constitution.
So is that a high crime and misdemeanor?
I would argue no, because technically, while it is technically considered arbitrary, it is not mentioned in the Constitution that those actions are not allowed.
Is the pardon power unlimited?
The pardon power is limited, well, the presidential pardon power is limited to federal crimes as listed in Section 1 or Article 1, Section 3 of the Constitution, that the president can only pardon people that have committed crimes against the United States as a whole. So
Well,
it's limited to federal crimes. The president cannot pardon impeachment as well. So, yeah, governors.
Well,
Sorry.
the question really goes to what types of pardons the president is permitted to give under the pardon power. Is that unlimited, and should it be or should it not be?
I would argue that the presidential pardon power is unlimited in the sense that if the president believes that he could pardon anyone, technically he could, and it's almost an unchecked power, in my opinion, because there could be a case of judicial review where the court could deem it unconstitutional to pardon someone. But I would argue that it is an unlimited power in the sense that I do not believe that that has ever happened in the past. And do I believe whether it should be an unlimited power? I would, in our current state and environment, political environment, I would like there to be a check on the presidential pardon, considering that throughout history it has been seen that many presidents in the lame duck period of their office, where they're about to leave office, they are passing many pardons. For example, Trump, or former President Trump, excuse me, he pardoned 116 people within his final days. President Clinton pardoned 140 with a few commutations. And then former President Obama pardoned 330 within his last days. And I, myself, would like to argue that that is an abuse of power. And I think that it would be beneficial if we could have some sort of check.
Just to disagree with my contemporary, I believe that, or I agree with her in the fact that the pardon power is an unlimited power in a sense, but I disagree that there should be limitations placed on it, because the pardon power is meant to act as sort of a mercy rule, and when not used arbitrarily, that's exactly what it's for. And the vast majority of the time, the presidential pardon is used as a mercy rule to show mercy to people who had either unjust sentences or something along those lines. And just because the president uses their pardon power a lot during their last part of their term, that doesn't necessarily mean that they are all arbitrary uses of power. That just means that they could be trying to make sure they get in all the pardons that they want before their term ends.
Good, Molly.
So what if it's arguably not for mercy? What if it is a former business partner or a family member? What then? Do you think that limits should be placed on those sort of pardons?
Well, the framers, George Mason himself thought that the president could possibly use the power arbitrarily, and he suggested that senatorial approval would be good for the pardon. But in the end, James Wilson said that the public opinion and the public view of the office would check this. So let's say that President Trump used a majority of his pardons on, or his lame duck period pardons on people that he was associated with. The public view of the office could then be changed, and he could either be not reelected or just not elected for any other public office. And I guess that'll place a big enough check on the pardon power to prevent them from doing that.
In the case of the former president, did that work?
Because the election was already over and it was the lame duck period, I do not believe that it has worked, but it is a little too early to see whether or not the public view of the office has changed, because former President Trump might be up for re-election in 2024. So we might see whether or not that plays a big role in the election.
So your team mentioned the QAnon shaman, which is an interesting historical character by himself, but I'd like you to go back and tell me more about what your thinking is about the QAnon shaman with regard to testimony.
Mr. Chairman, in regards to testimony with the QAnon shaman, I would like to say succinctly that what I was trying to imply was that if former President Trump were to pardon those involved in the insurrection, then the court could subpoena them and have them come testify, because technically they couldn't plead the fifth. And so it would almost be self-incriminating on those multiple points. So with Jacob Chansley and the QAnon shaman, if he were to be pardoned, he could be subpoenaed and during his impeachment trial per se, and testify against President Trump.
Okay. Thank you.
I'm a little confused about that. Are you saying that that would be a possibly affirmative or positive use of the pardon power?
I'm just saying that if it is a possibility within the impeachment that could be used, which is why he did not pardon anyone in the insurrection nor the Russia probe investigation either, because they could be called back to testify against him, and that's why you see lack thereof of pardons for those involved.
Good. So are they right that the Senate and the conflict between the Senate and the House has made the impeachment power meaningless? To the pardon power, I should say.
May I ask if you said pardon and impeachment? Which one are you talking
Sorry,
about?
I meant pardon. It was my fault. The time was up anyway, so we'll pull that one from the record. Okay, I'll go first, and then Molly, and then Ed. We'll give you some feedback. If you want to take a deep breath, go ahead. I was pretty impressed with your team's ability to answer some fairly difficult questions. We're not actually being mean. We're just trying to see where your preparation is and where your understanding is. I really like I don't like the QAnon mechanism itself, but I liked your use of it. You did a nice job your team did a nice job of weaving that in. I also like the fact that you took a stand on whether or not poor use of the pardon power constitutes high crimes and misdemeanors. You don't need to agree with us. You took a position and you defended it. That was good. Also, I like the idea of bringing up the judiciary, because we don't often hear, when we talk about checks and balances in seventh grade, we talk about the three branches of government rendering checks upon each other, but we don't really hear about it with respect to pardon. So I find that interesting, and I was intrigued by the fact you brought it up. I guess I also like the term mercy rule. And I think it's hard to know which examples of the pardon are flippant, as your team put it, and which are not. But I like the notion of the mercy rule, and I appreciate your testimony. Go ahead, Molly.
Excellent job, you guys. I thought that your historical knowledge for the question was very in depth. You clearly understood and knew what you were talking about, and I feel like I learned a thing or two, so I appreciate that. One thing that I would suggest for future panels is to address all of us. We're all here, we're all listening. Mr. Chairman, I'm sure was listening in very closely, but Ed and myself, we were also listening in. So we're all a part of it. So just include all of your judges. I thought that you all were very respectful of each other when you had difference in opinion, and I appreciate that. Everyone has their own sort of opinion, and the way that you presented it was very good. And lastly, let's see, Reed, I particularly enjoyed you talking about, well, we don't know if it worked yet, this pardon part. I liked your idea. I like to see how it's going to go, and I will keep what you said in mind. All right, Ed.
So thanks, guys. I really appreciated that. I thought it was an excellent presentation, and you did deal with some difficult questions, and Molly stole a little bit of my thunder there. I thought that the answer to my question about whether or not the check on the pardon power, if you will, which would be either impeachment or not getting reelected, is yet to be decided. I think it's interesting that you chose the second impeachment of Trump to use that analysis. And at the same time, I was thinking about the first impeachment and wondering whether or not that had an impact. But all in all, a nice job, good historical depth and reasoning. And thank you very much, and best of luck to you.
Thank you.
Thank you.
Thank you guys so much. We'd like to recognize the students for their hard work today. Congratulations.